Today, I will try to enumerate few scenarios and situations which will show how we are placed as a doctor, then we as a specialist, and how the law actually interplays with the healthcare professionals. Can anybody relate himself or herself with this number? It's 221. We memorized a lot of numbers, a lot of articles, but any guess? What's 221 is related with each and every medical professional? That is the situation. If we try to do a survey in some of the management college, some of the engineering college, and some of the medical colleges, that what is the Nifty today, probably you will get the best answer from the management college, followed by engineering college, and least from the medical colleges. So we are groomed to teach and be taught that what should do best for the patients, not for ourselves. This is the number is actually in the real world where we actually stand in the professional world. Whatever we believe is a godly phenomenon and professional autonomy, believe me, it doesn't exist in law textbooks or even in medical textbooks. This 221 is the number designed for the each and every modern doctors by National Classification of Occupation. And you will be surprised to see, if you go by the gradations of the National Classification of Occupation, the top level classification is Division 1 and stands for the legislators, officials, and the managers. Below that, that is 2, comes professional, what we are proud of. It's same with the doctors, lawyers, professors, etc., etc. And 2-2 for the healthcare professionals, and 2-1 is for the each and every doctor what do exist in India. This is the real life scenario. It is made by central government. It's one of the finest copy paste from the ILO classification of the occupation, which was done in 2018. So this is our scenario. Now, let's say we'd like to have a quick look, few scenarios and cases which is already in Indian textbooks and many medical legal scenarios. There is one case is a Jivan Kumar Raut and other in the Union of India. Improper sterilization for dialysis equipments is penalized and is treated as a negligence, and hefty amount of compensation was awarded to the hospital. Again, sterilization and disinfection is treated as an established negligence, and hefty amount of compensation is thrust upon the hospital authority. And don't think that as a doctor you can skip yourself from each and everything, because there are a lot of situations until proven otherwise. In every situation, as a doctor, you will be dragged down into the certain cases. There's another situation, I do not know because I am not a nephrologist. There's a mismatch in dialyzer membrane. I do not know how it works, but it's a case referred from the Kerala State Consumer Dispute Redressal Commission in 2018. It's a more or less recent case. Here also, doctors and hospital is penalized just because of the negligence due to mismatch in dialyzer membrane. Another case is Delhi High Court. It's 2019. Lack of trained personnel and emergency management facilities, in particular standalone and outskirts dialysis center, is also construed as a medical negligence, and also there is a liable for compensation. Atunu was referring that government initiatives. Yes, there is a case reference by Rajasthan High Court in 2020 that government should take initiative to improve and facilitate so the accessibility can be higher in case of dialysis and the related services. There is a specific case law. There is another interesting case law in case of, probably it is not directly interacting with the hospital authority or the doctor, but Fresenius Medical, in a petition, they have been awarded that 5% IGST to curtail down the costs of the equipment, instruments, and consumables of the things, whatever is being used in the dialysis. One most important thing, non-related kidney transplant, there is a gray zone, but as per THOA, it is acceptable, and it is also pronounced in by Madras High Court in 2023. There was a litigation, and Madras High Court uttered that non-related kidney transplant is not contraindicated under the Act of THOA. One more important thing, those who are interested in renal transplant, there is a case reference of Delhi High Court that whatever is the appellate authority, they must come out with their conclusion whether this transplant is allowed or not within 7 days dictum. I do not know how it is being followed in our state. And there is illegal activities. And Katie, it's not only violating the THOA, at the same time, it also violates the Indian criminal procedure. We always talk about there is a gray zone about how long we should keep the documents. The various kind of laws has been enumerated in the various way. In general, National Medical Commission, NABH, states for 3 years and 10 years for the medical legal cases and maternity and child cases. Consumer Protection Act, the Limitation Act, everything is saying 3 years. MLC and DGHS and Supreme Court ruling is 10 years, MTP 5 years, PCP NDT 2 years, Transplantation of Human Organ and Tissue Act says 5 years. So rule of thumb is if you are related to the transplant, then it should be 5 years. Other than this, generally 3 years, but most commonly we have to memorize that 10 years in case of medical legal and maternity and child cases. This is mandatory. We cannot avoid this timeline. One more important thing we have to remember that audio-visual consenting is mandatory in case of renal transplant. In case of any transplant, it's dictated by the National Medical Commission. Those who are involved in medical legal scenarios and kidney transplant, this is one of the backbone of how the consenting mechanism has to be done in case of renal transplant. There are a lot of penalties and punishments dictated by various kind of law. Even the NMC is the reprimand, warning, suspension of medical licenses, further education, and these provisions are enumerated in NMC. And under various kind of healthcare law, if you want to see, you will find it is more or less 3 years to 5 years in general under various kind of law. I want to enumerate and emphasize only one thing, which is we are not being very aware. There's a new amendments, our new IT Act and the Data Protection Act. It has a provision for 5 crore compensation. 5 crore. That means as a doctor, from your hand or from the hospital side, if any data breach which violates the patient's privacy, it may attract 5 crore compensation. This is the highest dictated compensation under any kind of law. In case of hospital, if they are being culprit and it is being proven, up to 250 crore for corporate punishment is dictated under the Data Privacy Act, Data Privacy Prevention Act in India, which was launched in 2023. So you have to be very careful when you are dealing with the IT things, because every hospital is now going IT enabled to make their life easy. I do not know how these things can be dealt with. Till today, most of the cases are for the clinical negligence in the consumer forum, only because that from consumer forum there is the provision of getting money. If this is in the public domain, the data privacy can attract 5 crore from an individual doctor and 250 crore from a corporate entity, then probably most of the consumer forum cases will be shifted to the IT and Data Privacy Protection Act. It's a horrible situation if we can conceptualize the future. Many other punishments is dictated by under various kind of BNS provisions, section 115, 117, 3116. I am not going into the details. At the same time, now we are coming to the very basic things to have certain understanding how we are being liable as a doctor. As a doctor, we are liable just like any other citizen. We do not have any extra privilege under any kind of Indian law. We have common liability as a citizen. At the same time, we have a professional liability. It's a threefold liability. We have liability towards the government, towards the hospital where you and me do work, and towards the patient. We mostly talk about the professional liability towards the patient. Usually we tend to forget that we also have the liability towards the institution we do work and at the same time towards the government. So anything and everything. One individual of Indian citizen have a liability as a citizen. We do not have any other thing other than that particular liability. We do have that liability. But unfortunately, now we are so liable that we have to think so many things other than the treatment. Now even Lancet came out with some kind of relief that has to be addressed towards the doctors, and that is our today's discussion, how we can play safe to keep ourselves happy, at the same time better possible patient treatment. There are 17 rights enumerated by Ministry of Health and Family Welfare. You can go through the ministerial website, even you can Google it, you will find each and everything is written there as the patient's right. But I haven't come across anywhere, any kind of article what is enumerated as doctor's right. So there are 17 rights. It's right to information, to right to be heard and seek redressal. In Indian law, nobody is stopping anyone to go to the police station and go to the court. No one. Because আমার যদি মনে হয় এখান থেকে গিয়ে আমি বলবো থানায় ডক্টর বিনায়ক সিনহা আমাকে ঘুষি মেরেছেন, ভারতের কোনো আইন নেই আমাকে এটা থেকে ঠেকাতে পারে, আমি প্রমাণ করতে পারবো কি পারবো না, দ্যাটস এ ডিফারেন্ট বল গেম. সো দিস ইজ দ্যান opportunity which is capitalized by many other professions, definitely not the doctors. Now we are coming to the most crucial part, where the doctors and patients do interact, because we always talk about doctors' autonomy, but believe me, there is nothing called doctors' autonomy. It's only the philosophical concept. It has no real ground in the reality, something called doctor's autonomy, and patient's autonomy is already there. So what is the concept of doctor's autonomy? It is a relegated discretionary power as a professional, and the professional discretion, it is dictated and guided by the paternalistic model, patient autonomy model, or shared decision-making model, and consumer-based model. In India, most of the time, we actually tend to do shared decision-making model. And this model is guided by medical council, various patient and doctors' right, and constitutions and law. It's not free. I cannot do whatever I wish to do. So it is guided by various kind of laws and various kind of regulatory commissions. And patients, they are the representative of our common society, and it is an institution of outlet of business and politics. If you see, or if you consider the government institutions, their outcome from a hospital is a little different rather than the corporate entity. For corporate entity, it's very straightforward ROI and what should be the maximization of the profit. But in the government setup, it is the same way, but it's a different flavor. The most of the hospitals, how much bigger society that this hospital can serve, and we can have a better, stable healthcare infrastructure in our state or in our nation. So outcome is ultimately, it will be entrusted and enforced towards the doctor only. This is the reality, and you cannot bypass the pestle concept from anywhere and everywhere. It's already and always there, just like God and thin air in the hall. It's always there. Every doctor is cautious about the negligence, because most of the till date case references are due to the negligence in the various kind of forum, mostly civil cases and the consumer forum cases. We have to understand very fundamental things, what the negligence actually is. So there are few chronological events. One doctor and patient, whenever we're coming to the patient's services, you have duty. If there's duty, there is any breach, it may be ethical or it may be legal. If that breach causes some sort of injury, and if that injury is followed by damages. So fundamentally, if any patient comes to you as a doctor to consult you or for any kind of treatment, we have as a doctor 4 specific duties. One, to consider whether I am taking this patient or not. It depends on your situation and your specialty and how do you want to deal with it. Either, if it is not a life-saving emergency, you have every right to refuse the patient, but in case of life-saving emergency, you cannot refuse the patient. This is first. So if I are taking the patients, then we are responsibility to treat the patient. And this treatment also includes diagnosis, guideline for the treatment, and the implementation of the treatment. Last third point is very catchy. That is the implementation of the treatment. Say, for example, you have given insulin to a particular patient and nurse gave overdose of insulin. Patient, there is some kind of complication. The liability will come to the doctors first, then the nurses, because it is the vicarious liability. It is supposed that under whom the patient is admitted, everything is dictated by the consultant or the treating doctor. So everything will come in his shoulder. If this chain can be proven, there was a duty, there was some sort of breach, and that breach caused actual injury, now the negligence is proved. If the negligence is proved, under various segments of law, it can be dealt in a different way. It can be punitive, it can be temporary or permanent deregistration, there may be compensation, and there may be recommendatory actions. So one mistake or one litigation can lead in different forum, having different kind of compensation or punishment or outcome, whichever way you look at. Little understanding of what the actual injury is. In BNS 14, it is defined as the illegally caused any person, any body, mind, reputation, and property. Generally, we talk and we deal with the bodily injuries, because in case of healthcare industry, bodily injury comes first, then mind, reputation, and property. But that also can be dragged down under the laws of tort. We'll have a glimpse of laws of tort. So this injury, if comes, so whatever the actual monetary compensation or the monetary equivalence of that injury, that is termed as damages. There is a lot of difference between damage and damages. Damage is a common English, but damages is a legal English. It means what is the money equivalence of that particular injury. So here is the gray zone. We will come how to handle this gray zone. Ultimately, these damages will be calculated by whatever cost incurred for the treatment, what is the cost will be incurred for the handling the injury, and what is the earning potentiality loss. If somebody, say around 30 years of age, earning is 1 lakh rupees per month, and if the patient died, the total amount of compensation will be calculated considering the patient next 30 years of earning potential and what is the incurred cost in the treatment. So there is a calculation called multiplier method. The rule of thumb, it's a very complex calculation. We don't need to calculate so many things. We have to memorize certain specific thing, life expectancy minus victim age into annual income. This is the highest possible compensation possible under consumer forum or consumer courts. So we have to understand it is not the same thing if we deal with a billionaire and deal with somebody who earning is 15,000 or 20,000, because compensation will be calculated according to the persons or the patients, what is the earning potentiality and what is the earning probabilistic earning lost in future. So it's a very dangerous situation because multiplier method is being applied many of the cases, and we can see the hefty amount of compensation in case of negligence once it is proved. Now the gray zone is how they are being calculated. There is certain amount we can see, say for example, we are dealing a patient, so we have done treatment, it is a cost, it's a investigation, hospital charges, doctors, etc., etc., say for it's a rupees 100. Now the compensation also includes pain, amenities loss, etc., etc. How they are being coming into the consideration when the total entity or total amount we can see, it comes from tort law. Tort law, to understand tort law, it is little difficult. We have two types of damages. One is the liquidated damage and another the unliquidated damage. In case of contract act, whatever you can figure out, that is will come under the contract act. What we cannot figure out, say for example, আমার খুব মন খারাপ, আমি 7 দিন এক্সট্রা হসপিটালে ভর্তি থেকেছি, এই মন খারাপের কোনো ম্যাগনিটিউড হয় না, কোনো কোয়ান্টিফিকেশন হয় না. It is the court's discretion how they will actually monetize this mon kharab. This mon kharab will come under unliquidated damage because we cannot quantify that particular monetary equivalence of this mon kharab. So this is unliquidated damage. We cannot overrule the unliquidated damage the mechanism we can establish, we can bring everything unliquidated to the liquidated damage. That mechanisms we can adapt in our practice as well as in the hospital. To conceptualize, we have two different laws which is dealt under criminal law. It is the criminal laws. Apart from that, everything is under civil law. In civil law, there are specific acts. It may be Contract Act, Trust Act, Consumer Protection Act. If something is directly coming to under any act, that's fine. That will be dealt with with that particular act. On top of that particular act, there are free zones. So this is the pink. This is the grayish domain, which is not covered by any specific civil act. That will be dealt under tort law. So tort law we cannot avoid. It's a law. It is the Indian Constitution fixed duty to each and every individual, including doctors with their professional capacity. So tort laws will be there. What we can improvise mechanism that we can bring certain things under the Contract Act so the domain of tort law can be minimized. We cannot make zero. Legal point doesn't say that it will be zero, but we have mechanism to come down or bring it down within the Contract Act. So we have to practice safe. This is the lamp lighting for each and every conferences to light the lamp for the knowledge. So today I am talking about the knowledge for ourselves to have a safe practice and better life. So litigation and compensation is a risk factor to each and every doctor. So we need to design something, particularly the financial aspect, how we can deal with it. Very difficult to define safety. I could not find any particular word or line how to define safety. So I took the help from mathematics, where the risk tends to zero. It's never zero, but it tends to zero. So we should adopt certain specific measures where we can minimize our risk towards tends to zero. That situation will be called safety. So we have to have our financial education and financial backup to have a financial freedom. If you have a financial freedom, only there is a freedom. Otherwise, there is no freedom actually. I don't believe in that concept. In real life scenario, what will actually happen? So there is a lot of paperwork so you have done. Patient came to the chamber, treated, and then discharged, died, whatever it is. If the patient is unhappy, they will go with this full set of paperwork to another doctor or to a lawyer, more commonly a lawyer. So a set of papers will go with that particular patient. As per law, if the patient is asking for the papers and the documents, hospital and individual doctor is bound to provide within 72 hours. So patient has the full file. Now it goes to the lawyer. So they will investigate and have a outlook, what is written there and what is not there. Then everything will go to the court. Both the side lawyers will argue. There will be expert witness. And at the end of this whole exercise, there will be some kind of judgment. It may be favorable to you and me. It may not be favorable to you and me. So we need to improvise strategy so that we can prevent, protect, and handle if any kind of situation occurs. So from this slide, we can understand in the court of law, what will be evaluated is not what you have done in your clinic or in the operation theater. It will be evaluated what is written and what is not written. So every time, every litigation, there will be set of papers will go and examined by the various specialists, lawyers, judges. There will be argument. At the end of the whole exercise, there will be also direction in papers. It may be favorable, may not be favorable. So can we do something with these papers and with this whole exercise? Tala tokhoni bhanga jabe jodi ami talata banate jani. So if we can understand this whole flow of stages or flow of events, then we can improvise certain things. I can assure you it's not illegal, but you may not like how the lawyers think actually to manipulate things in a scientific manner. This is our real life scenario. Patient came to you. So we have documented everything, patient's details, complaint, comorbidity, history, previous surgery, but unfortunately never ask the financial details. The question is why? Whatever. But we in generally do not ask any patient, what's your monthly income? If you feel, if anything goes wrong and compensation, we have to bear with the calculation as per the financial details of that individual patient. So we must have an understanding what is his financial capacity. So we have to extrapolate something how the financially he is stable, and if this patient die, what could be the maximum compensation awarded. It's a rule of thumb. It's not 100% perfect, but we can have a rough idea. So we have to improvise certain mechanism to squeeze or scheme out the financial details. Next, what happened? We have made the note down of everything: examination, investigation, diagnosis. We have given treatment, refusal or treatment or discharge certificate. So if you see in this whole exercise of our daily life, nothing is written by the patient. Nothing. Each and every word, each and every line is somehow something narrated by the patient, written by the doctors only. Now, problem is that if I write something, I cannot disown it. If I write 50 patients, I am seeing 50 patients in a clinic, then definitely after 20 patients, I lose little bit of my patients. It's occupational psychology, and definitely there will be chances of error, and it should be. So we can curtail down something, we can improvise mechanism. So whatever the patient is saying verbally, you can ask them to write, because history, it is supposed to what is patient is saying. Our concept is we are trying to do everything on our own. We need to understand how to de-shoulder certain responsibility to the other side of the table. Because if a patient writes something, if you make a list, what are the medication he's taken, what are the previous procedures or previous surgical incident happened, if the patient doesn't write anything, so in case of future litigation, you can say all this documentation is made by the patient himself. But if I write or you write on behalf of the patient, say for one common example, I am surgeon, so I am giving a surgical reference. I have done an appendicectomy and there's something litigation, something went wrong, and patient went to the court and said, हमने तो बायां तरफ बोला था डॉक्टर साहब, क्या अंग्रेजी में लिखा मुझे मालूम नहीं. Can you challenge this? If you have a audio-visual consenting facility, that is fine. Otherwise, if the same patient says, वो तो डॉक्टर साहब क्या पर्ची में लिखा मुझे मालूम नहीं, मुझे तो अंग्रेजी आता भी नहीं. So you cannot overrule this kind of scenario. I am not saying that every patient is bad. I am trying to say how to play safe. If the same thing, even the patient is known by Hindi or Urdu, whatever is the language, if you ask them to write what is his complaint, what is the medication, and what are the previous surgical procedures, it will help to assess the patient. At the same time, if anything goes wrong, then you will have to say something, this is the patient declaration of suppression of fact. Actually, that will be productive for your case in case of litigation. So ask your patient to write certain things, and you can design what are the things you should include that kind of form to safeguard yourself. It will depend according to the domain, according to your practice, and definitely your client base. So we have to ask them to write something, and we also need to modify little bit of our writing pattern, because our writing pattern is medically correct, may not be the legally correct, but at the court of law, it will be treated whether it is legally correct or not. Medically correct, some expert will come in, and we do believe doctors do write correct thing in as a medically, because it is very difficult. You are for a painkiller, you are prescribing a Pentodac, not a paracetamol. It is very unlikely. So we are not coming into the details with assuming that we are trained and competent enough to write medically correct prescription, but we need to emphasize little bit on legally correct information. Next, we have taken care of all the liabilities. So we have to modify or limit our liability. Everybody travel through aeroplane. So if you go by your ticket, you will see there are a lot of situation. In case of national, it is baggage lost claim maximum is 15,000. In case of international travel, it is 25,000. So whatever is maybe in your baggage, but insurance company will provide you, or aviation industry who is liable to pay you up to 15,000 for national carrier, and in case of international, it is up to 25,000. So now industry has made something, they are capping their liability. But in healthcare, we never have seen such a initiative where they try to cap their liability. I am not saying that this will save you, but this is a mechanism by which we can attempt, because our fundamental concept is we have to bring the tort liability towards the contractual liability. So once it is written, whatever is written and calculated, it comes under the contract law. Whatever is not written or not calculated before the incident, that it will come under the tort law. We cannot make zero, but we can definitely improvise certain mechanisms. We always take the liability, whatever the patient is saying, we try to understand, but we can also ask them to bring the interpreter in case of any language barrier. You officially mentioned if there is a cross-pathy or not, but that will also save in long run, and recognize the pharmacist. And there is a dushtumi buddhi. If you write in your prescription the position for a pharmacist with a stamp and with their registration number, I can bet you 99% probability is no pharmacist will be available during the selling of that particular drug. There will be some salesperson. In some of the institution or institutional pharmacy, there can be on-site present pharmacists, but most of the situations that won't be. Now, if anything goes wrong, if you say this drug was bought from a non-recognized medical store, I cannot say that is 100% safeguard, but this can be a mechanism, because there is a column for the pharmacist registration number as well as the stamp which is not there. So recognize the pharmacist. This can save your back, and definitely we have to incorporate mediation and arbitration clause, because mediation clause is now recognized by all kinds of civil act, including the Consumer Forum Act. At the same time, in 2013, new Company Act also incorporated mediation clause. If we always incorporate certain mediation clause in our consenting and documenting format, then it can help the healthcare facilities directly going to the litigation, because they has to pass through the mediation institution. There are many civil contracts you have seen, there is a clause for arbitration. So wherever there is an arbitration clause, it directly cannot go to the court. They have to route it through the arbitration. If you can keep a mediation clause, then as per law, it has to route through the mediation. At the end of the mediation, say for 5 years or 10 years, this patient can go for a litigation that I am not happy with whatever is said or whatever is settled in the mediation. Yes, but at the end of the 5 year, why these so many litigations happen? Because most of the situation they dealt with certain lawyer and they say, okay, apnar ja ache case ami lore debo, case ta jitle amake 40% deben. So he is not paying anything out of pocket. But if you designate certain mediation institute, as per rule, the fees will be per sitting. 7 দিন 10 দিনের পর একটা করে সিটিং হবে, তাকে পকেট থেকে দিতে হবে। And if this same mechanism drags down to 1 year or 2 year, যেটা খালি পয়সায় হয়ে যাচ্ছিল, সেটা আর হবে না, most likely এই লিটিগেশনটাও ছেড়ে দিতে পারে। It's not sure shot, but this can be also a mechanism if we can incorporate mediation clause in all of our documentation and consenting mechanism. That will also certainly limit our liability. We have to prove shared decision making. Not following the advices properly, we always say, আপনারা ডায়াবেটোলজিস্ট, মিষ্টি খেতে না করেছি, কটা মিষ্টি খেয়েছেন? আপনি কিন্তু লেখেন না যে হি টুক সুইটস। রাইট ইট ডাউন, নোট ইট ডাউন, মেক দেম রাইট যে হ্যাঁ আমি মাঝে মধ্যে 2-4টে রসগোল্লাও খাই। It implies that he is not following your direction, because you are liable only if the patient is following a direction in toto. If there is a variation from the patient side, it will also contribute to the negligence, and that will be termed as a contributory negligence. Again, it is not absolute, but you can have your safe your back little bit of safe. Supervision of facts and or wrong information, request or refusal, ask them to write whatever is refusal. ডাক্তারবাবু আমাকে 7 দিনে ছুটি করে দিন। Ask them to write a letter as per your requirement. Don't say যে ছুটির জন্যই চিঠিটা লিখতে হবে. Ask them, whatever the format required, mail it to me. again it is a document, because our problem is whatever is the documents in the healthcare scenario is available, it's from our written document, not anything from the patient side. So my suggestion will be, you ask whatever they're saying or requesting, write it down, and then do whatever the suitability for that particular individual or particular patients, and must not forget about the financial calculations. So these are the various kind of conflict or litigation management. So if we have to understand, start with discussion and it ends with force. In between there is a negotiation, mediation, arbitration. All these are legal entity. Don't be afraid of litigation, but channelize through negotiation, mediation, arbitration. From mediation there is a special act and special law. Now it is included each and every civil law, including Contract Act and Consumer Protection Act. So incorporate mediation and arbitration clauses in any kind of consenting form or forms, whatever we have in our hospital or in our clinic. And last but not the least, we have to understand how to modify our documents. As a doctor, we always tend to believe and tend to understand more as health. So health has three parameters. It has physical, mental, and social parameter. It is my effort to make you understand the prescription and document within these three terminology and bracket, so it is easy to comprehend and easy to remember. So whatever documentation we do, we have paper and ink. Everybody has experience going to city center, Inox, KFC. Have you ever seen the bills? It's official, it's legal. But if you keep it in your money bag or wallet, after 2 days, probably you won't be able to read anything. I am not saying again it's a 100% proof, but yes, we can deal with little bit of with the paper and ink, how paper and ink we use. We tend to use the best possible bond paper as our prescription. Whoever is practicing in a hospital, it's not in his own hand, but whoever is practicing in his own clinic, they tend to believe that what is the best possible paper I can have. Now, if you use the worst possible or cheapest possible paper and you write a prescription, and probably this will attract moisture, by 6 months, then nothing will be readable. And there is supposed to be one copy to you, make a carbon copy of the same, and whatever it is, boঝা না গেলে তো কিছু করা যাবে না. It is little bit of legal bending of mind, not a pure medical jargon, how lawyers think. একজন লয়ারকে পড়ে বুঝতে গেল আগে লেখাটা পড়তে হবে. So any patient who is for a litigation going to a lawyer, he has to show the paper first. If that paper is nothing is readable, then he will come to you with a letter that I need the documentation. Fair enough, give the documentation. But in case of IT enablement, this mechanism is very difficult, because once, I have learned from my IT friends, once a document or anything created IT-wise, it is never deleted. So be very careful whatever you are documenting and whatever document you are creating in the IT. But as long as we use the usual paper and pen, so we can play certain things with the paper and the ink, that is scientific as well as legal. We need integration to our colleagues, so that we should not upfront criticize to any of our colleagues, because at the end of the road, the expert opinion will come from the another specialist or another doctors only, and never, never, never. We need to be integrated with the social power axis. As a doctor, you may or may not be in the limelight, but we as a professional, we are not in the social power axis. So we have to realize that because nothing is possible in this world without the pestle enablement. If we can do little bit of improvisation and modification from our side, and then let's see the fun. That's all for today. We tend to believe certain things. It is a conceptual design thinking. It is actually originated from the Stanford B School. They are conceptualization, empathize, define, ideate, prototype, and test. Similar things we can do or try to implement with for the best of our own interest without doing any harm to anybody. So analyze, fix the target, find the available ways, take the shortest possible way, and perform, and just this loop to be again and again and again. If the outcome is fine, carry on, and think about how we can do little more better. If the outcome is not desirable, again go and analyze how this should be done. That's all for today for our sustainable practice. We do run few medical legal courses, now they're available online. And if you have any question, that you are most welcome. Thank you very much.